1, 2, 3 into the foe. Markwell Cade of Cade Mark Law is at your door. Back with another resource for you. I have a lot of clients that come to me and need estate planning help. And one of the first questions they always ask is, what estate planning documents should I have? Well, everyone typically knows about a will, or a last will and testament as it's also called, but very few people know about these other things we're going to discuss today. Today's topic: 2 other documents that you must have if you want to have a good estate plan. Disclaimer alert, before we get into those 2 must-haves, everyone's estate is different. And because everyone's estate is different, everyone's estate requires a customized plan. This means you're going to want to consult with an attorney when you're building your estate planning documents. But generally speaking, these 2 documents we're going to discuss are documents that every good estate is going to have in their arsenal. The first must-have is a disposition of last remains. Now, a disposition of last remains is just a fancy legal term or a fancy legal jargon for what is going to happen to your body when you pass away. You can be cremated, you can be buried, you can be turned into one of those little tree pods or one of the other alternative burial methods that we have in the modern society. But a disposition of last remains will be important because you want to outline for your heirs and the people that you leave behind on what they should do with your body. What are your last wishes as it relates to your body? Do you want to be cremated? Do you want your ashes to be scattered in some special place? You want to specify this through a disposition of last remains, as your will often won't discuss these things. A will and last testament is going to be for bequeathing the things that you leave behind, but they aren't going to necessarily outline what to do with your body or your remains. This is why a robust estate plan will also include a disposition of last remains. The second thing that any robust estate plan will have will be instructions or a letter of instructions to the testator or to the heirs. This letter of instructions will outline everything from your Social Security disability benefits to the passwords that you left on your phone or your accounts so that your loved ones can get into those accounts and maybe close your Facebook, for example. They're also going to be very important for any other instructions on maybe where you left your will, where you left important keys to real estate, property, or other items that you're leaving to your heirs in your will. This letter of instructions is not quite a legal document, but it's very important for giving your loved ones instructions on what to do after you pass away. They will give them instructions on everything from where you left important documents, to what passwords are for your accounts, to what is important for considering when they're doing your estate. You want this letter of instructions because you don't want any confusion for your loved ones that you're leaving behind. This means that this letter of instructions is one of the most robust things you can include in an estate plan. Without including it, you're leaving your loved ones at a little bit of a disadvantage. This is why it's a must-have for your estate planning. That's all, folks. Thank you so much for joining us today. This has been 2 other documents that you want to have if you want to have a robust estate plan. Once again, I am Markwell Cade with Cade Mark Law, your favorite neighborhood lawyers. Protect your brand, grow your business. Stay frosty, my friends. We'll see you next time. We hope this was helpful.